Hi everyone, and welcome to our first webinar about Web3 legal. Today we have a very interesting topic, but before we start, let me check the connection as usual. So please send plus to the webinar chat if you can properly hear me and if you can see the slides. Today we will discuss some visual concepts and some charts which are very important when it comes to the token distribution and token issuance legal structuring. And as usual, we split these webinars into two parts. The first part will be more like a content part, and I'll explain you some general ideas of tokenomics legal structuring. We will discuss some very important questions related to the token legal status, to some countries which are friendly in terms of token issuance and token distribution. We will also cover a bit a token cap table, so it should be quite productive for the Web3 founders especially. And that will be the first part, the content part, and the second part we will spend for a Q&A session. So I would like to invite you to send the messages and your questions into the chat. Please feel free to send the feedback or the queries that you have. I'll try to cover as much as possible in the end of the webinar as the second part of this webinar. So to briefly also make an introduction, just a few words about myself. My name is Nestor. I'm a co-founder of Legal Notes, and I'm working as the international legal specialist for Web3 and blockchain companies. I work with them since 2015, and since that time, we collected some use cases and experience that I'll be happy to share with you today. I also conducted more than 100 legal sessions to help the founders to navigate around different regulations. And I'm also a contributor to the Legal Notes Resource Center, where you will be able to find more detailed explanations about the different Web3 legal concepts, which we also will discuss today. Speaking about Legal Notes, this is the platform that helps Web3 founders to solve cross-border legal matters. And this platform and our service acts as the dedicated legal managers for the Web3 founders when it comes to solving the cross-border legal matters. We call this service Virtual Legal Officer, and the role of the Virtual Legal Officer is to be this intermediary between the founders and the global network of vetted local legal professionals that are in Legal Notes network. Virtual Legal Officer will help the founder to clarify some options where different companies might be registered, and also help to engage the most relevant registered agents, qualified lawyers, data protection specialists, etc., in each of these countries, and help the founders to manage their work, to check the price and time estimates, and to update the status of each this legal tasks. So all legal matters, especially the cross-border one, might be managed and solved in one place, and where the virtual legal officer will act as the single point of contact. So coming back, and just also a quite important disclaimer that this presentation is not a legal advice. So please consider it as just for the informational purposes. And all this content that we will discuss today will be also just for the informational purposes only, and will not be a legal advice at all. So, to make a very brief introduction before we discuss the proper agenda to this webinar, I would like to ask the question to our auditor today about the main reason why the most of Web3 products usually plan to issue tokens or usually need to issue tokens. And considering some, taking into account and remembering some conversations with the Web3 founders, I also would like to answer on these questions according to my own vision, and according to my own understanding, what is the core role of tokens in the most of Web3 ecosystems and Web3 products. And basically, that's some kind of asset which is very important for user engagement in the Web3 infrastructure and in the Web3 ecosystem. And basically, it's not just about the user engagement. It's also about some other quite important reasons, like community building, like fundraising, and like creation of some added value inside the Web3 product and inside the Web3 ecosystem. So basically, these three reasons are something that I would like to highlight to you today when it comes to the main reason of token issuance. And I would like to focus more on the third reason why the most of Web3 founders want to issue the tokens, and that's about the fundraising. There is quite an interesting dilemma of the most of Web3 founders when they start their journey and when they start thinking how they can structure their fundraising campaign. And the dilemma is about the difference between the token capitalization versus equity capitalization. Because in the end, it will be very important to define what will be the core asset of the company and how to calculate the valuation of the company using this core asset. And we will cover it a bit more later on in our conversation, as it's pretty straightforward for the Web2 companies, which usually have just equity, they have just shares, and their main idea is to grow the valuation of their shares and grow the capitalization of the company. It's a bit different in the Web3 area because the most of the founders usually start with the shareholding company, but in the end, their main goal is to create this fully decentralized autonomous organizations, which usually don't have this shareholding structure. Otherwise, they have the community of people who are usually the token holders, and the main asset that connects these people and helps to structure all of them into the form of this decentralized organization is token. And that's why we will speak more about the token legal structuring, token legal status, token cap table, and token distribution process today. And in the end of the webinar, we'll also discuss how this valuation dilemma or Web3 company capitalization dilemma might be solved with the proper regulatory and legal frameworks. And speaking about the closer topics to our main webinar topic today, we will speak about the legal documents, and we will speak also about some regulatory compliance, about the countries that might be token friendly, about the different approaches that countries might apply to different types of the tokens. And that's especially relevant and especially important for the Web3 founders who plan to issue these tokens, because today there are no very well established regulations in this sphere. That's why the Web3 founders should be very careful when it comes to token issuance, and that's why they need to check as many different regulations as possible, and to receive and to conduct as much legal analysis as possible to be on the safe side and to make this token issuance and token distribution in the compliant way. And basically, the most of these Web3 founders usually face the following questions: the countries where these tokens might be issued, the licenses and authorizations that might be required for this token issuance and token distribution, and also the KYC and AML compliance, as all matters that might be relevant or might be somehow connected to the financial and virtual assets will probably trigger the AML and KYC compliance. And that's why this also should be taken into account when structuring the token issuance and token distribution plans. This results our today's agenda, which I would like to start with the general overview of tokenomics and some types of tokens and their legal statuses. That's super important because each legal status of different tokens will have its own legal consequences when it comes to this type of token issuance and token distribution. And please consider this all classifications and uh, definitions uh, as they are created just for the legal purposes and from the legal perspective, because I guess that today there might be some people with the great tokenomics background, and they probably might have some different point of view on how to call one on another parts of the tokenomics and the tokenomics at all. My idea today is to provide you some general idea of the classifications of all these parts of tokenomics from the legal perspective. That's why the next question that we will discuss will be about the token capitalization table. We will discuss briefly the token pools and the token recipients. Then we will discuss the token distribution plan, because each of these token pools will have its own category of the token recipient and its own way of how the tokens might be distributed through this token pool to this and token holder. And in the end of the webinar, we will discuss more about the token company and its role in the whole Web3 legal structure and its main area of responsibility. So I hope this webinar will be useful for you. Let's start from the first question. And basically, it's about the tokenomics. The general idea is to split this concept of tokenomics into three parts. The first part is the token utilities. And basically, these token utilities mean that this is the list of all token use cases that might arise when the potential token holders will receive their tokens, which means that this will be the scenario how these token holders might use their tokens, how they can spend it or send it or sell or do some other activities. So whole this list of these activities or these use cases will be included into the token utilities. Secondly, it's a token cap table, and we have already briefly discussed that this token cap table concept will include the general token issuance, the token pools or different token allocations, and the end recipients for each of these token pools. And the third part of the tokenomics concept is related to the token distribution plan. And this token distribution plan is more about the way how the tokens should be sent, transferred, or distributed from each of these token pools of the token cap table to the end recipients. And we'll be able to see this on the chart, so I hope it will be more understandable a bit later. And why it's so important from the legal perspective? Because each of these part of the tokenomics will have its own legal requirements, details, and consequences that should be taken into account when structuring the tokenomics at all. Speaking about the token utilities, it will have legal requirements to define what might be the token legal status and which requirements might be applied for this specific token in some specific markets or countries according to these local regulations. Secondly, the token cap table is something that will be super important for the fundraising, especially when it comes to the SAFT preparation, which is a very important, very popular document for the Web3 fundraising. And speaking about the token distribution plan, that's something that will also be very important when the founders will start thinking how they can distribute the tokens to each of the category of token holders that they plan to involve into their Web3 ecosystem. Let's start from the token utilities, as this is the first part of this tokenomics concept. As we discussed previously, and again, that's more the legal perspective onto this general tokenomics idea. The main or the general idea of having the tokens in the Web3 ecosystem is to push the user engagement, is to increase it and to make the users more interested and more motivated in using the Web3 product by suggesting them or by offering them this added value in the form of token that might be used somehow in this Web3 ecosystem. And that's general the idea, to incentivize the users of Web3 product by allowing them to use the tokens inside this Web3 ecosystem. And when we speak about this general goal, we need to define what are the ways how this user engagement might be increased and how the users might be incentivized by the tokens. The methods are different, and just for the example, we can highlight a few one. For example, it might be this token incentive model for the end users might be structured in the form of consensus algorithm rewards, and that's something that might be the way of how to motivate the validators or oracles of some blockchain protocols and implement this gas fee for the blockchain protocol if the end users would like to launch their own decentralized app using this specific blockchain network. Secondly, we can discuss some discounts, loyalty programs, reputation scores, memberships, access to some specific functionality of the Web3 projects, etc. That's also some kind of way how the users might be motivated having their tokens and user their tokens inside the ecosystem. And it also might be some more like traditional benefits. For example, the dividends, the voting rights, the tokenized derivatives, or some other tokenized real assets that might be wrapped in this into this blockchain-based form of unit of account, and then use it for some specific activities. And basically, these methods, these token use cases, results some token legal qualifications. And among these legal qualifications, we can highlight different types of the tokens. And on the screen, you can see the example of how this methods of token usage might result the token legal status in different countries. Among these token legal statuses, we can speak about the protocol tokens, which are usually used as this some form of a gas fee, for example, for the users who plan to launch this decentralized apps in the blockchain protocol. We can speak about utility tokens that might be used by users who plan to actively use the Web3 product, need some access to some special or exclusive functionality, or would like to have a discount, or would like to increase their loyalty score, loyalty program, etc., etc. And speaking about this more like complicated ways of how to motivate users, including the dividend distribution, the voting rights, etc., that will probably be something related to the security tokens. And speaking about this different types of the tokens, the next question which is very logically to discuss is how to issue and distribute each specific type of these tokens. How to issue and distribute utility token or protocol token or security token, what will be the legal requirements, the regulatory details that should be taken into account, what should be the compliance, and the main criteria when it comes to thinking about the countries where this token might be issued or the regulatory frameworks that might be friendly for the each specific type of the tokens. We can highlight just one super important criteria: the regulatory certainty. This is super important, as especially on this early stage of Web3 market development, as not all of the countries have already passed clear and proper regulations with the clear definitions of tokens, their different token models, different models of token distributions, different types of these virtual assets, etc. And that's why this criteria of regulatory certainty is super important when it comes to choosing a country which is friendly for this specific token issue. Among these token regulations, we can discuss the token-related laws. That's quite a mature type of token regulations. The token regulatory guidances, that might be more like a light version of the token regulations. However, it doesn't mean that it's less important. That's also super important to consider it. And also some token regulatory tests. And here you can see some examples of the countries where the specific laws or guidances or regulatory tests are passed or prepared. If we speak about the token-related laws, we can speak about the virtual asset service providers regulation in Cayman, or some specific token-related regulation in Liechtenstein. At the same time, if we speak about the token regulatory guidances, the Switzerland, Singapore, and Hong Kong are the countries that have already passed this token regulatory guidances, provided their own view on the criteria which should be applied to each type of token to define the regulatory status of this token, and as a result to define which types of regulations will be triggered if this kind of token will be issued. For example, if it will be the security token, it will probably not be enough to take into account just this token regulatory guidances, but it will also be super important to make a clear analysis of the securities law, financial law, anti-money laundering law, etc., etc. At the same time, if it's a utility token, probably some token-related regulations plus some consumer protection regulations and some taxation conditions should be considered for issuing such kind of token. And that's the same for all of the countries, but some of the countries made a better progress and have already created this more clear overview and the regulatory view onto different types of the tokens. And the third category of the token regulations includes the token regulatory tests. So basically, this is the set of criteria or the system of criteria that allows the Web3 founders to apply the system into their specific token and receive the score of this token on what is the probability that this specific token might be recognized as the security or the financial instrument or the e-money or the utility token, or probably some other kind of digital asset. And these countries include Malta, Bahamas, and the United States, which probably is hard to call the crypto-friendly country, but at the same time, this is definitely the country with the very clear position on how the tokens might be qualified there, considering that there is a HOI test there that helps to understand what might be the legal qualification, and where there is a very well developed and established securities law that also should be properly analyzed before even thinking about any token issuance and token distribution from the US-based company. So that's about the token utilities, about this first part, and about the token legal status. Let's move to our second question, which is about the token cap table. And generally, I would like to suggest you to split the whole token issuance that might be planned by the founders. Let's imagine that the Web3 founders plan to issue 100 million tokens, and we need to create a clear token cap table which will reflect how this, what will be the allocations, the token allocations or the token pools inside this 100 million tokens. And in general, I would like to suggest you to split this token issuance into two general parts: the insiders part and the community part. That's the general idea how these parts might be split into more precise token pools. If we speak about the insiders pool, that's the pool that is usually allocated for the team, for the advisors, for the founders, and for the fundraising purposes. And here you can also find more about some numbers that are usually used by the Web3 founders when they structure their token cap tables. If we speak about the community part or the DAO part, we can discuss the following token pools of this part. The validators pool, they might also be called as the Oracle pools or the pools for the some infrastructure participants which will participate in this different consensus algorithms, etc. Then we can discuss liquidity bootstrapping pool. That's usually the pool which is very important to boost the token distribution and to boost the awareness of the tokens among the community. We can also speak about the community pool, which is basically the pool where the end token holders and the Web3 product users will be able to get some portions of the tokens by conducting some tasks or by purchasing them or by doing some other activities that the Web3 founders would like to motivate the end users to do by using this token concept inside their Web3 project. And there might also be the reserve fund just for some token price stabilization purposes or some other purposes that might rise in the future. So that's the general idea how this whole token issuance of, for example, 100 million tokens might be split into two different parts, and then how each of this part might be split into some specific token pools. And that's something that's super important from the legal perspective. It's without the proper explanation or the proper structuring of the insiders part of the token cap table, it will not be possible to prepare a SAFT. And the SAFT is the document that is very well known among the Web3 venture funds, and this is a very popular instrument for Web3 companies fundraising. There is also the reason why it's important to have at least general overview of the DAO part or DAO related token pools might be structured, as this is something that is very important to reflect in the white paper or the DAO constitution or some other concept paper of the future DAO structure, to make it transparent for the community and to also provide the investors with the general idea which kind of and which ways of token pools and token distribution are planned to be implemented in the future when the DAO will be launched. Just a few words about SAFT. We will discuss it a bit more on our next webinar, which will be on next Tuesday, about the fundraising. So please don't miss it, and you are very welcome to register to it and join it. From the token cap table perspective, the SAFT is very important, as this is the document that includes some clauses that require the information from the token cap table. And these clauses might include the total amount of tokens to be issued, the token price, the token pools, especially for the insiders, token vesting conditions or the token lockups, and also the date of token issuance, which will be reflected in the SAFT as the conversion event, and which should be clearly communicated to the investors, as this is the moment when the investors may expect to receive the tokens of the project. That's why the token cap table, at least in the part of the insiders, is super important for the SAFT preparation. Coming back to this token cap table concept, we have already discussed this some general idea of how which the token pools might be included into the token cap table, but that's not enough. The second part of the token cap table, which should also be reflected in the when the founders will prepare the token cap table, is the token distribution plan. And this is a very important part of the token cap table, because this is the way and the explanation how the tokens will be distributed from each of these token pools. if we speak about the team pool, which usually include the founders and the employees or the team members and the token holders, we can speak about some token transfer agreements or token vesting schedules that will be applied for this, and according to which the founders and the employees we will be able to clarify their expectations when they can receive different portions of the tokens from the general token pool. The same with the advisors. They also usually have this token option and token vesting schedule, which is linked to their advisory agreements. And speaking about the fundraising pool, that's something that will be definitely asked by the investors, as this pool will be used for the SAFT conversion, for the token sale agreements, for some other token sale activities or other ways of paid token distributions. And the investors will need to know all these details that we discussed on the slide about SAFT, because they should be reflected in the legal document and also reflected in the token cap table. There is also the same approach for this DAO part of the tokens, and each of these pools might have all its own end recipients. For example, if you speak about the validators pool, it might be the validators, oracles, or node holders, and who might expect this rewards from the protocol for supporting the consensus algorithm. It might be the liquidity bootstrapping pool that might be injected into some liquidity platforms like exchanges or wallets to allow the end users to make different token swaps or buy and sell tokens. There is also the community pool, and this community pool is also super important and probably one of the biggest pool of the token cap table. The main idea of this pool is to use it to incentivize the end token holders, the Web3 product users, by allowing them to stake the tokens, to receive some staking or yielding rewards, to airdrop these tokens, and to grow the community, to push the engagement of the users, and to grow the awareness of the project at all, and the value of the project and the valuation as well. And the reserve fund that's usually logged by the DAO for some specific reasons that might be reflected in the white paper. That's the example of token cap table structured in the form of Excel table. I hope this example might be useful for you, because there is, for today, there are no very well established online solutions for token cap table structuring. That's why most of the token cap tables are structured in the form of the regular tables in Excel. But I hope it also will be useful for you, as this document will help you to easier communicate with the investors, and also to communicate with your community and DAO how you plan to distribute the whole pool of tokens that were issued by the smart contract from the on-chain part. That's the general chart of the same cap table, but in a more user-friendly way, where you can see these different pools, which might have a different percentage from this whole token issuance, where all the recipients are reflected, and you can see these different categories. And in the end, where each way of token distribution is reflected as well, to clearly define how each of these token pools will be spent for each category of end token holders and end token recipients. And basically, for the purposes of token distribution and from the legal perspective, it might be convenient to split this token distribution into on-chain part and the off-chain part. And here you can see that off-chain part is the definition that might be more related to the insiders token pool and to the distribution of tokens to the insiders, as it's usually structured in an off-chain way, where it's necessary to sign the legal agreements to define both parties of these agreements, where from the Web3 founder side should be a properly structured token company that we will discuss a bit later. And from the insider side, there should be the identified individuals, investors, advisors, and some other types of companies that will receive these tokens. At the same time, if we speak about the DAO pool, that's something that is usually distributed on chain, where the DAO were launched and where this on chain part of the project has its own rules how to distribute each of these pools, like validators pool or liquidity pool or community pool, to each of these categories of users. And it's in the most of the cases it's structured in a more automated and this autonomous and decentralized way. That's why it might be called the on-chain distribution. So let's focus briefly about the off-chain distribution. And as I discussed, that's something that is usually done in a more off-chain way. There are a lot of founders might think about this type of distribution as some kind of ICO campaign. It's also might call it IDO or a token generating event or an initial DEX offering or initial coin offering, etc., etc. But the reality is that between these two parts, the insiders token pool and the insiders themselves, there is a huge amount of legal works that should be properly structured to be compliant in this type of token distribution with all regulations and laws. Basically, first of all, it should be clearly defined the token distribution method, whether it will be the token transfer with vesting, which is usual for the founders and the team, whether it will be token options, which is more common for the advisors, whether it will be public or private token sale, which is more related to the fundraising campaigns and for the Web3 venture funds. Then the legal documents should also be properly prepared. Different token options agreement, token advisory agreements, SAFTs, private token sale agreements, public token sale terms and conditions, and some other documents that might be required by each specific way of token distribution. And in general, the token regulatory compliance, because signing the documents in the most of the cases, will not be enough. There should be also the clear procedures how to verify these users, these investors, these token buyers, this Web3 venture funds, how to define the source of their cryptocurrency that they will use to buy your tokens, and what is the status of the token to distribute it in each specific country. Because, for example, in one country, this token might be distributed without any legal obstacles and specific legal requirements. At the same time, in another country, it might be required to obtain some specific token authorization or token legal opinion to be allowed to distribute this token with the specific legal status in this specific country. And the last, but not the last important question, but I guess it might be also one of the most important one, is the token taxation, because this is also something that might differ from country to country, and that's also something that should be considered when it comes to the token distribution, to the off-chain token distribution from the insiders token pool to the insiders like founders, employees, investors, advisors, etc. And that's where this token company appears. And that's the moment when we need to discuss this breach, this legal breach between the insiders token pool and the insider themselves. And this company will be responsible for all these legal works that we discussed previously. That's not all about this company, because we also have the second part of the whole token issuance, which is more related to the on-chain token distribution. And that's the tokens that are usually distributed from the DAO token pool to the DAO itself, which is a decentralized autonomous organization. And that's also the process of token distribution that should be covered by the token company, which will transfer the second part of the token issuance to the DAO. and allow the DAO in the end to distribute these tokens in more like an on-chain way to the community. So that's the chain of these token distributions, and that's the scope of work that is usually important to consider to structure this token distribution in a compliant way. To sum up the role of this token company or the responsibilities of it, we can speak about the on-chain and off-chain token distribution. And on the previous slide, you had a chance to see how this token company acts as the intermediary or as the legal bridge between the token pool and the token recipients. It's also the fundraising because, as we mentioned previously, among the insiders are the investors who will need to sign legal documents to invest the funds, and the token company will be the legal entity from the Web3 founder side, which will cover these compliance matters and sign the legal document. And also token listing on exchanges and wallets. Basically, that's something that this token company will also be responsible for, as this token company will be responsible for passing these listing procedures, KYC procedures, obtain the token regulatory approvals, token legal opinions, and provide all this information to the exchanges or wallets to ensure that this token might be distributed also through some third-party platforms like crypto exchanges and wallets. And that results also the compliance matters that should be covered by this token company. And as we previously discussed, it's token legal opinion, it's this KYC and AML procedures. Also, it includes different authorization and licenses depending on the legal status of token and the way of how the tokens are planned to be distributed. And also the token-related taxations, which might differ from country to country, and which might also result some tax consequences for both token company, investors, token holders, etc. And that's something that also should be clearly analyzed before starting the token distribution. Previously, we briefly discussed some countries which have already passed some regulations or guidances or prepared the token tests to make more clear regulatory status of tokens in their countries. And to sum up all these countries, the main recommendation for token company registration is to take into account all these different pieces of regulations and use these two main criteria to check what might be the legal requirements for token issuance and token distributions in each of these countries. Among these two criteria, we can speak about the token legal status, whether it's utility token, security token, payment token, asset-backed token, protocol token, NFT, or some other type of the token. Each of this type of the token will probably have its own set of legal requirements in different countries. And secondly, second criteria is the way of how these tokens will be distributed, because each way of token distribution might have its own set of regulatory requirements. For example, if it will be the private token sale for the Web3 investors, there might be some list of or some checklist that the Web3 funds will require from the token company, like to obtain token legal opinion, to clarify the token taxation consequences, to define whether it's necessary to obtain some token regulatory approval or license to issue the token there. At the same time, if it's a public token distribution or public token sale, the list might be much longer and include more compliance, different KYC and AML procedures, more complicated licenses, etc., etc. So to sum up, that's two main criteria that should be used when considering different regulatory frameworks for token issuances and token distributions. That's all for today. I hope it was useful for you, and thank you very much for your attention. Just a very short announcement about our upcoming webinars. It will be the webinar about the fundraising for the Web3 projects. It will be on next Tuesday, so please register to these webinars. I hope it will be useful for you, because we will discuss there are different investment instruments, especially for the Web3 industry. And the last webinar that we will make on next week will be about the DAO legal structuring, and that's the end goal of the most of Web3 projects, to become a proper decentralized autonomous organization. And we will discuss what might be the legal structures for it, and what the founders need to take into account from the legal perspective. That's all. Thank you again for your attention. You are very welcome to ask the questions. I'll be happy to cover it on this quick Q&A session in the end of this webinar. Also, in case you have any specific token-related questions, please feel free to book a legal session using this QR code, which you can see on the screen. And again, I would like to invite you to our next webinar, which will be about the fundraising. We will discuss different stages of Web3 product development and which kind of legal documents might be the most relevant for each of the stages of Web3 fundraising. So, looking forward to receiving your questions, and we'll be very happy to explain it. Probably it might be something related to the token cap table, or something related to the token distribution plan. And that's the parts of the tokenomics at all. And I guess that this structure, this tokenomic structure, which includes the token utilities, the token cap table, and the token distribution plan, might help the founders to better understand how to approach this complicated legal world, and define some regulatory requirements for each part of this tokenomics. So it seems that there are no questions for this webinar, and I'm again very happy to have you in this webinar. Thank you very much for your attention. Hope it was useful, and looking forward to meeting with you on our next webinar. Have a good evening and goodbye.